Everyone. I'm Haley Hansen. I'm the leader of the higher education team here at Husch Blackwell, and we want to thank you for joining us today. Before we begin, I'm going to cover a couple of housekeeping matters. At the bottom of your audience console, there are multiple application icons for use during today's presentation. First, if you have any questions, you want to make sure that you hit the question box, and Abby and I will do our best to answer any questions that come in. To be honest, we have a lot of content today, so we're a little concerned on time, so we may not get to all of your questions, but if we don't get to your questions, we'll make sure we send you an email responding to your questions after the webinar today. So feel free to submit them because we really do think they're helpful. Also, if you go into the program material folder, you will see the presentation. Oh, it doesn't look like I'm on screen anymore. Abby, can you see me?
I see a black box.
Oh, so do I. Well, that's who I am for right now. Sorry, everyone. Technical difficulties, I guess. It didn't hit anything, but I'll go through the introductions and then we'll turn it over to you, Abby. So again, the PDF of the presentation materials is available in the program material folder at the bottom of your screen. The program has been approved for legal education hours and credits, so you can click on the CEU icon at the bottom of the screen. You'll also receive a certificate of attendance, including the course number, and it'll be emailed to you tomorrow along with the recording of the webinar. And feel free to pass that recording on if there's others who couldn't attend at your campus that you think this would be helpful to watch. Also, towards the end of the program, we would ask you to complete a short survey. It's very helpful that a lot of our clients and others that attend our webinars have great topic ideas of things that are going on at their campuses, and we'd be really interested in your feedback and planning for future programming. So with that, hopefully my camera will come back on. I'm going to introduce my co-presenter, Abby Felter. So Abby provides regulatory advice to both educational institutions and consumer financial services clients. She has been and sees herself as a lifelong student who loves reading, studying, and understanding complex theories. Prior to joining Husch Blackwell, she worked for the U.S. Supreme Court for 3 years, annual Supreme Court yearbook of cases and decisions, and again, into the law and examining and interpreting the history of the law. So we're very happy to have Abby with us today, and I'm glad that she's on screen and on camera, even though I am not. So let's go ahead and talk about our agenda. First, Abby's going to talk about the Gramm-Leach and safeguard rule, and then I'm going to talk to you about what we know for the regulatory update. Then we're going to discuss third-party servicers. We're going to give you a federal forecast, and then finally end with negotiated rulemaking and what we see for negotiating rulemaking. So with that, Abby, I'm going to turn it over to you.
Thank you, Haley. Like Haley said, we have a lot to get to, so I'm just going to jump right in. So the GLBA has one rule called the safeguard rule. It's just one portion of the GLBA, Gramm-Leach-Bliley Act. And it initially took effect in 2003. It was recently amended in 2021 to keep pace with current technological trends. The gist of the safeguard is that institutions need to establish cybersecurity standards under which they evaluate and protect consumer information. So all Title IV institutions, whether you're public, private, nonprofit, for-profit, must comply with the GLBA's cybersecurity requirements. Additionally, third-party servicers are required to comply with these requirements. What type of information must be protected? It's customer information. For institutions of higher education, this typically occurs when students provide information while the school is administering Title IV programs, or if they're making institutional loans, including income share agreements, or if they're certifying or servicing a private educational loan. The requirements of the GLBA do have some flexibility. This means that the safeguards at a small school might look slightly different from the safeguards at a large institution. However, the objectives of the safeguard rule remain the same for all institutions. or institutions should be ensuring the security and confidentiality of student information, protecting against threats, and protecting against unauthorized access of information. On the slide, you'll see several of the key changes to the GLBA safeguard rule. We're going to be covering a lot of this information today, but I want to take a moment to focus on the qualified individual aspect of the rule. Institutions are now required to designate a qualified individual who will be responsible for the information security program. These individuals can be employees of the university, or you can outsource this to other entities. However, the FTC has been clear that if you're outsourcing to other entities, ultimately the responsibility of safeguarding the information is going to come down to the institution's responsibility. The qualified individual can have a different title. It doesn't necessarily have to be qualified individual. There are no strict degree requirements for the qualified individual, and it can look different depending on the type of activity in the information an institution stores. Regardless, the qualified individual will be required to report to the board of directors for each entity. So the safeguards are all about trying to control and identify risks. So in order to control these risks, you have to identify it. The best way to do this is to take an inventory of the type of information that your institution stores and where that information is stored. Once you've done this inventory, you can develop a written assessment protocol. This written assessment must be written, and then it also will address what types of risks are posed to each set of information stored by an institution. Once you've done this, you can start to implement safeguards such as encrypting information, setting up multi-factor authentication, and other sort of protections, especially when information is in transit. Institutions must also monitor, test, and train on their safeguards. There's two options when it comes to monitoring. Institutions can implement a continuous monitoring protocol, or they can do periodic penetration testing. If you opt to do the penetration testing, you also have to do vulnerability testing every 6 months. And there's a reporting requirement to the board based on the results of those tests. You should also be training your personnel in your safeguards and testing the systems as they go. Institutions should also create an incident response plan. The plan must include several different elements, but one of the key features is making sure that you have clear responsibilities for the key personnel that are going to be responding to different incidents. Being able to delineate different decision-making authority and establishing that beforehand will make the incident response plan a lot more effective. Additionally, you're going to want to establish procedures for fixing identified weaknesses and vulnerabilities, and then documenting and reporting the incidents to higher up personnel, and this can include the board. One change in the new GLBA rule, the safeguards rule, is there's an exemption for institutions that store less than 5,000 information for less than 5,000 consumers. This exemption applies to the written risk assessment, the continuous monitoring or the periodic penetration testing, the written incident response plan, and the qualified individual written report. So the rule initially took effect in January 2022. However, the compliance deadline was recently extended to June 2023. But it's really important to keep in mind that a lot of these requirements are not things that can be implemented overnight, and they do take some time to develop and train your people on and just implement these plans overall. So we recommend getting started on this if you haven't already. Enforcement is also a very interesting topic. So the FTC has enforcement authority over the safeguards rule. And we have seen evidence that the Department of Education will be submitting, they're going to do annual audits, and if there's a safeguard violation found, they will be submitting this information to the FTC. However, it's possible that the Department of Education could also have some enforcement in this area. Each institution is required to sign the PPA, the Program Participation Agreement, which contains the safeguard rule. And then another area where the Department of Education could enforce the safeguard rule would be under the administrative capability regulation. An element of being considered administratively capable is having sufficient safeguards in place. So long story short on this, I think we could see some action from the FTC, but I wouldn't rule out an enforcement action by the Department of Education. And with that, I will turn it over to Haley.
Thanks, Abby. And the camera's working again, so that's exciting. Apparently I broke the last one, so we had to get a new camera. So anyway, all right, well, let's talk a little bit about Title IX regulatory update. So what are we seeing? As you probably all know, on June 23rd of 2022, the department released its notice of proposed rulemaking and went through the notice and comment period with 700 plus pages that modified the current regulations that went into effect in August of 2020. And so as we kind of look at what we're hearing from the department in terms of timing, we're still hearing, and again, take this with a grain of salt because this is all, we're reading the tea leaves and what we're hearing from the department, but that they are going to hopefully issue final regulations if on track in May of this year, and then with an implementation date of August of 2023. So that's what we are hearing. Now, I will tell you, when the last round occurred, we were hearing things that the department was going to be able to move quicker than the department was actually able to move. So I'm not sure, but just so it's on your radar, that's what we're hearing in terms of when these changes that I'm going to be talking about today would be implemented. And understand, until they're implemented, and there'll likely be lawsuits regarding some of the changes, that the August 2020 regulations have the force and effect of law. So what are the key concepts as we look at kind of the changes in Title IX? First, the new standard of enforcement, kind of setting that standard, really expanding protections, and in many cases in the 700 pages talked about restoring victims' rights and victim protections against all types of sex-based discrimination, and then prohibiting exclusion from programs based on gender identity. So a lot of inclusion regarding gender identity as well. So from a high level, what we're talking about is, again, the advancement of this goal that no person experiences sex discrimination in any education program or activity that's receiving federal financial assistance. And so looking at it very, very broadly and restoring those vital protections that were, from the Biden administration's perspective, eroded by the implementation of the 2020 regulations. The other kind of general objectives and of the proposed regulations is to give clear rules to institutions. And I think that's been something that has been welcomed in a lot of cases. And as we talk through some of these specific changes, some of them are very helpful. Some of them still needed some clarification under the draft regulations. And I think the notice and comment period will probably take that into effect. Also strengthening protections for LGBTQI+ students, and very clearly identifying Title IX's protection against discrimination based on any sexual orientation or gender identity. And I think generally schools are already doing that, and are doing that under the current regulations, but just expanding those protections as you move forward with the potential new regulations. So let's kind of break this down and talk about what are the most notable changes, and specifically the scope of coverage. So it explicitly includes, as the definition of sex discrimination, pregnancy, sexual orientation, gender identity, sexual stereotypes, and sex characteristics. So that's new. So that would be an expansion. And a lot of these ways we're going to talk about expanding the definitions of what is covered under Title IX. Hostile environment. So this has been something we've been grappling with, what Title IX versus Title VII. The department, if these changes go through, will have settled that because they are actually modifying the definition of a hostile environment, sexual harassment, back to the Title VII standard. And that is that unwelcome sex-based conduct is sufficiently severe or pervasive. And so it's not severe and pervasive and objectively offensive as it is under the current regulations. So this just, as we say, kind of takes it back to a Title VII standard for cases that fall under hostile environment. The next is quid pro quo, and some of the changes regarding quid pro quo I think are very helpful because the department really clarified that it applies to agents or other authorized individuals by the institution. So somebody who is providing aid, benefit, or service under the institution's education programs and activities would fall under quid pro quo. However, the department was very clear that it doesn't apply to students in leadership positions for extracurricular activities. I think this had been a question for a lot of institutions of whether or not it was quid pro quo could include those leadership positions for student-on-student harassment and quid pro quo harassment specifically. And so the department has been very clear on that it does not apply to students within those leadership positions. Next, jurisdictional scope. So harassment occurring outside of the education programs and activities can, so this is different than the current regulations, nevertheless violate Title IX if it contributes to a hostile environment on campus or in an education program and activity. So essentially similar to what we saw in the Obama administration, but not as expansive as the Obama administration, but going back to if the harassment that happens outside contributes back to a hostile environment being created in your education programs and activities, you are responsible under Title IX to investigate, versus the kind of clear line that if the conduct did not happen in your education programs and activities, you did not have the obligation to follow or to investigate under the Title IX policy. However, you may investigate under one of your other policies if you are normally taking action against a student or even an employee for conduct that's happening outside of education programs and activities. So I think that's really important. And again, as you look at that jurisdictional scope, it's changing to be more expansive than we saw with the 2020 regulations. But Title IX is still not going to apply to harassment occurring outside the institution's education programs unless it, again, it ties back to some sort of hostile environment that's created on campus or your educational programs, or outside the U.S. where the harassment does not contribute, again, to a hostile environment on the education programs and activities in the U.S. And so you'll still have those issues when it comes to Clery. If somebody is in an overseas program and they are complaining of sex-based harassment or discrimination, something that falls under Title IX in the United States, if it doesn't contribute back to creating a hostile environment, it's outside the jurisdictional scope, but you can still have your own policies. And remember, under Clery, you still have, if it is under your geography, a separate campus or even non-campus property, you'll still have obligations to report if those incidents have been reported to you. So I think that's an important change, but one that is kind of nuanced. All right. The grievance process. It expands the application of the grievance process requirements to all forms of sex discrimination, not just sexual harassment as currently written, but it includes additional requirements for sexual harassment complaints involving students at post-secondary institutions. So I think that's something that There's not a lot of change when it comes to, as you're going to see in the next couple slides, when it comes to student-on-student claims. When a student is not involved, though, we have seen a little bit more leeway and potentially policy changes that you'll want to consider when the final regulations are published, and you'll have some time to determine what your policy will look like in these areas, especially what your grievance process looks like. One of the major expansions, and I do just want to highlight this because I think it is really important to note, is the redefined definition of retaliation. And it now includes intimidation, threats, coercion, or discrimination against anyone because that person has reported possible sex discrimination or made a complaint or participated in any way in the Title IX process. So it's very broad compared to the current definition of retaliation, and specifically adds in the definition that there can be peer retaliation. So retaliation by one student against another student can fall into the definition of retaliation. And that, I think, has gotten a lot of comments because a lot of schools are very concerned. Of course, you want to prevent and have policies against retaliation, but that is an expansion from where we've seen it, the law previously, before these, again, new regulations would go into effect. There are some less stringent procedures. I've listed them here up on the slide. A couple of them that I think are important are that complaints can now be made orally or in writing. And remember, before, the process didn't really start until you had that formal complaint. And so, you had no, that was the starting of the written formal complaint. Mandatory dismissals are now going to be permissible by the institution, but not mandated. And so that will change things a little bit as well when you talk about how the process is working. So a few less stringent procedures under Title IX than we've seen before. A notable change regarding as advisors is that the right to advisor is preserved when it comes to sexual harassment complaints, including that involve a post-secondary student, but that in cases of sexual harassment that do not involve a student or just sex discrimination complaints, that an advisor is not necessary. So think about things like employees or third-party complaints that maybe don't have anything to do with students. Then you could revise your policy to not have advisors as part of your policy if you chose to do so. Making sure confidential employees and mandatory reporting. I think these are two areas that are important. Employees whose communications are privileged under the law, this kind of goes back to our Obama era guidance as well, are associated with their role at the institution. So a licensed counselor, somebody that's in the clergy that's acting in that role at the school, those types of individuals will still have confidentiality and will not have to report. But the new regulations would kind of require institutions to open up that reporting mechanism again. And a lot of institutions never changed it, honestly. I've seen a lot of policies that I work with that they still had mandatory reporting, even though they didn't have to have that under the 2020 regulations. So we're seeing a lot of that work go on as well. All right, live hearings. So it eliminates the requirement of a live hearing, so you can use a single investigator model. However, you still have to figure out how you're going to allow cross-examination in a single investigator model, or how you can allow for that type of examination. And so that's something that your policy would have to address. So not going back to just the single investigator model as we saw in the Obama administration. It's got to be something different if you decide to remove the hearing process as you're assessing what is best for your institution. And then cross-examination, again, if you have live hearings, the decision maker must determine relevance of the advisor conducted questioning prior to the party answering. and the decision maker should not permit questions that are vague, ambiguous, or harassing of the other party being questioned. And so this, I think, got a lot of comments as well, because the word harassing, some complainants will state that being asked about the sexual assault that they that was perpetrated against them is harassing in nature. And so I think there needs to be some more clarification regarding what does that mean? But again, a requirement of a live hearing. And if a party does not respond to questions regarding their credibility, the decision maker must not rely on any statements of that party that supports that party's position. So again, talking about the remnants of the exclusionary rule, essentially, and as we look at how do you assess credibility when you have these types of complaints. Determination, so notice of determination need not be in writing or include any specific details in sex discrimination complaints that do not involve students. So again, going back to having a different process for third-party complaints or employee complaints if a student is not involved. But you must provide a written determination of whether sex-based harassment has occurred in cases involving students. And so that has not changed. And then the expansion of the Title IX coordinator's duties. So we thought it was hard to keep a Title IX coordinator because their job is really difficult, honestly. And now it's going to be even harder to keep one because there'd be even more responsibilities added to that position. And they include regular campus climate surveys, targeted feedback from students and employees that have reported or made complaints about your process and how does it work. Public awareness events, which a lot of campuses are already doing, but receiving feedback about how your process is working and what are the issues regarding the current process. And then publicizing and monitoring an email address designated for anonymous feedback about reporting barriers. So that's another, and that was part of the kind of the notes that went along with the proposed regulation changes as to the interpretation by the department, that would be something that the Title IX coordinator would be responsible for to make sure that your process was moving in was appropriate and you were addressing any barriers to reporting or issues within the process itself. So is everything settled then? Well, of course, not everything's settled because everything changes when it comes to Title IX. And so, an update on where we are in the current regulations, the exclusionary rule was vacated in August of 2021 that you would exclude information or anything that had been previously given if somebody didn't show up to the hearing. And this comment by the court was very, very interesting, recognizing the fact that if you had a client that had said something and you didn't want that inculpatory statements that they had made either to the police or to the parties, they wouldn't hesitate to advise on this. And so I thought that was very interesting and something that we'd all been talking about as we were grappling with the exclusionary rule. So no, nothing is settled. You can anticipate, again, I would say the soonest you will see the final regulations would be May. Now, as soon as I say that, they'll be published, next week or something, but we anticipate May still with an implementation date of August, giving institutions time to change their policy. I think one of the most important things you need to take back from all of these changes are that there's a lot of areas in which you as an institution get to decide what your policy is going to state, and that's going to require some buy-in from the cabinet, from your president, from the institution itself in terms of how do you want your Title IX policy to move forward. One of the biggest things being, do you still want to have a live hearing process, or are you going to try to craft a new way to meet all the requirements under a single investigator model? And so those are things that if you haven't talked to your presidents, your chancellors, your cabinets, those individuals, obviously your general counsels are very aware of this. That's something you might want to do as you move forward and anticipate these changes. All right, Abby, I'm going to turn it back over to you to talk about third-party servicer, which was I think shocking to some as we sent out our legal alert on that a few weeks ago. So I'll turn it back over to you.
Thank you. So yeah, we're just going to jump right in with this. This is the definition of third-party servicer in the Higher Education Act. And traditionally, I think, the Department of Education institutions, they understood this to mean people that were traditionally associated with administering Title IV within the normal understanding of that phrase. So things like dispersing aid, return to Title IV calculations, and just stuff that was normally done by financial aid offices that you might outsource to third parties. However, recently, I think it was February 15th, the department expanded their interpretation of the third party servicer definition to include a catch-all provision, and they expanded specifically in 3 different areas: student recruitment, software products and services linked to Title IV, and educational content and instruction. So the Dear Colleague letter that announced this interpretation has these charts, and the charts that they have actually have a little bit more information, but basically it goes through and it helps institutions understand whether or not an entity would qualify as a third-party servicer. So here in recruitment, unless your recruiter is only conducting, hosting, or assisting with community awareness or public service FAFSA completion events, or publishing, mailing general student financial aid information, policies, procedures, and handbook, they're likely going to be considered a third-party servicer under this new rule. So things like interacting with prospective students, assisting students with completing applications, processing admission applications, anything like that is going to trigger the third-party servicer rules for recruiters. Similarly, we have a chart for the computer services and then the software and record maintenance. The operable question in these instances tends to be, what amount of information do these third parties have access to? If they have access to the data, they probably are going to be considered a third-party servicer. But if they're just warehousing records and they do not have access or control over the data, then they likely will not trigger that definition. Similarly, with providing software services, you'll see it has to do with whether or not through manual or automatic processing, these individuals or entities have access to the financial aid management, the recruitment and enrollment, admissions, registration, billing, or other learning management information. In terms of instructional content, I think a lot of times people think of this as OPMs, where they're providing a percentage of the Title IV eligible program. These are now going to be considered Title IV or third-party servicers. Things like establishing course requirements, completion requirements, and evaluating whether a student has met those is going to be considered a third-party servicer. Similarly, delivering instruction or mandatory tutoring, assessing student learning, or developing curricula or course materials is going to fall under that third-party servicer rule. So what does this mean for institutions? Well, luckily, the department has extended the deadline. Initially, they released a Dear Colleague letter with an immediate implementation date. They received some constructive criticism and adjusted that date to allow institutions until September 1st to report any arrangements with third-party servicers that have not previously been reported. Also, while you guys are doing this, I think it's really important to just take an overall inventory of the contracts that you have with third parties and consider whether or not this would meet the new definition of third-party servicer. You may consider also revising your contracts with these individuals to make sure they are meeting the third-party servicer requirements. You should obtain a signed certification from each third-party servicer, and you should make sure that your EAP is updated to identify any third-party servicers. So what does this mean for vendors or third parties? If you're a vendor and you're now covered under this third-party servicers rules, you're going to have to probably update your contracts like we just discussed. But you also are going to have to submit a third-party servicer data form to the department, and you must meet annual audit requirements. Your audit requirements may differ based on the type of activity you're doing, so we recommend taking a look at the audit guide and considering what sort of things you need to start documenting and compiling in order to be able to comply with the audit requirements. I think I'm gonna mention one more thing on this impact on vendors. We've already talked about the safeguard rule and the GLBA as that applying to third-party servicers. There are also other things that might apply to third-party servicers, like being jointly and severally liable with institutions, and the audit requirement, which we discussed. So just keep in mind that there may be additional requirements. So next steps. We've discussed this, taking inventory of your arrangements and making sure you're communicating with outside vendors. Also updating contracts and that sort of thing. The comment period has been extended until the end of this month. I believe it's March 29th. So if you want to submit comments to the department, that is still open. And then tomorrow and Thursday, there are going to be listening sessions where the department is going to hear feedback on this from the community. Going off of that, the department also has recently issued an announcements related to personal liability for individuals. And so the way this would manifest is the department will ask certain individuals at schools to sign the Title IV program participation agreement. The schools that we believe the department is most interested in are going to be the ones that demonstrate a financial risk to taxpayer dollars. And the department has signaled several risk factors, including significant audit findings, failure to meet financial responsibility requirements, legal actions related to fraud, misrepresentation, consumer harm, or financial malfeasance, significant compliance issues, or executive compensation or bonus structures that could significantly affect the financial health of an institution. There's been a lot of debate among insiders whether or not the department has the legal authority to do this and to what extent they have the legal authority to do this. And so this is an interesting topic to keep an eye on as it evolves. And then with that, I am going to kick it back to Haley for the federal forecast.
Yeah, Abby, I think we should have just a small little discussion of what you're talking about regarding third-party servicers as well. We've gotten some comments in the questions that have come in about that the department may provide additional guidance, and we think that's probably going to happen. At least it may be informal or formal guidance in terms of a Dear Colleague letter or something else, because there's been a lot of uproar regarding this when it just came out, and there wasn't a lot of information, because as you can imagine, there's a lot of potential vendors that qualify under these of a third-party servicer, and that's significant for the vendor and significant to make sure that, again, your contracts are updated. And so we do think that there will be additional information from the department. Abby, don't you agree that is probably forthcoming, and that these listening sessions are going to be important to kind of hear where the department is going, especially on things that are not quite as clear right now?
I think that's exactly right. We are going to attend the listening sessions tomorrow. That way we kind of get to see what people are saying and see if the department weighs in on the comments. But we fully expect additional guidance just because of the scope of the change. It's not a small change. It's a pretty big change. And I think the fact that they initially asked for or set it up to be implemented immediately, but have kind of rolled that back, signals that they might have miscalculated kind of the breadth of this change.
I agree with you, and also think that also potentially signals the fact that there will be legal challenges as to whether or not there's the legal authority or the authority, that there should have been additional comments and maybe going through the notice and comment rule, going through a different process than what the department had done. Now, Possibly not, but I do think we could anticipate that there will be some that want to challenge this as well because of the significant impact it has on institutions. It's another regulatory burden that institutions are going to need to make sure they're complying with and have pretty standard language in their contracts as they're working with third-party servicers to make sure that you're covered and meeting all the requirements as set forth by the department.
I definitely agree.
So yeah, we'll get to some of the questions hopefully by the end, but I do want to just set the stage for what we're seeing from the federal government in terms of the federal forecast before we get into the notice and comment rulemaking process. And so what we're seeing specifically, the Clery Act, there's been proposed legislation that would, it's called the Campus Accountability and Safety Act, that would increase transparency and reporting requirements regarding Clery. So as you all know, Clery was enacted in 1990, and it's been one of the only laws that has over the history of its, as it's been modified and changed, has had a lot of bipartisan support. There's never been a time in which there hasn't been both Republicans and Democrats that are very interested in campus safety and Clery. And so we do think that that's only going to continue to expand whether this act is passed or not. But it would create a campus safety website for each institutions, and some institutions are already doing this. And in fact, as you look at some of the more recent audit findings from Clery audits that have occurred, that's one of the things, at least in voluntary resolutions, that campuses are agreeing to do is create this campus safety website, establish new resources and support services for survivors of campus sexual assault. So that is something, again, that the overlap between Title IX and Clery that we continue to see, and this uniform process to adjudicate sexual assault cases, that would all be in a law. Now, as written, that may differ from some of the proposed regulations. So we'll kind of have to see, again, if this actually is passed or has additional support. But it's clear that there is bipartisan support for the Clery Act. The other thing just to mention, and again, I'm reading the tea leaves here, so please don't hold me to it, but what we've heard is that there's going to be a new Clery handbook, and it's supposed to be out as soon as this summer. Now, I've said that at times in the past, and the handbook doesn't come out, but my understanding is that they're working on a new Clery handbook as well. The old handbook has been rescinded and been replaced by the addendum and amendments to for when it came to and is part of the program reviews that are done under Title IV. And so now I think there's some, I guess, drive by the department to put a handbook back in place and move forward with being and clarifying some of the things that have been withdrawn when the previous handbook was withdrawn in October of 2020. All right, next one. Program participation agreements. So Abby talked to you a lot about about third-party servicers. Now this is requiring you to have updated PPA signatures if you have a sole member of an institution or somebody who has substantial direct or indirect control of the institution, that those individuals now need to sign the PPA. And so things you can think about are a nursing school, which is controlled by a hospital system. Then their sole member would need to sign the PPA and be responsible for everything under the PPA, just like the nursing school would. And that the entity provides audited financial statements for the institution's annual financial submission. So a lot of institutions, they'll roll up their audit report. They don't have a separate audit. They may have a separate schedule, which meets the requirements for the department and their accreditor, but they don't have a separate audit itself. And so any of those types of entities, if you are one of those entities, your next PPA will require signatures of anyone who meets this definition. So something that we're seeing evolving and wanting to, that again, as Abby talked about additional liability, it seems like the department is really trying to focus in on individuals with control and make sure that if they're taking federal financial aid, that they are on the hook if things don't go well, if there's issues regarding their compliance. And then finally, accrediting agencies. So as you all know, regional accreditation, the distinction between regional accreditation and national accreditation is no more, and hasn't been around for a while now. And so institutions, I think there was at least some, when that regulation went into effect, there was some thought that, oh, this will be easy to change accreditors. This is not going to be, we have lots of choice, and we're going to be able to change very quickly. That's not the case. And now the department has said institutions must apply to switch accrediting agencies. You must receive approval from the department. So you must outline why you want to change accrediting agencies, and whether the department will actually determine then if you have reasonable cause to change accrediting agencies. Requests to change an accrediting agency will be rejected if it's due to bad standing with the accreditor or an attempt to lessen oversight of the institution. And so if it's attempts to have less stringent oversight, because as we all know, that creditors have different standards, different criteria for accreditation, those types of things. If that's the reason you're trying to change, then those will be rejected. Approval will only happen if you can demonstrate that the change in accreditor will improve the institutional quality. And so that's going to be important. So it's a pretty high standard to apply for a new accreditor. And it takes a long time as well, as you know, because you are as you switch accreditors, you are going through the new accreditation process, and you will be in that process for quite some time. So just additional clarification regarding changing accreditors. Okay, so let's move on to our last topic, and we only have a few minutes, we only have about 13 minutes left, but I think this is one of the most important topics that we're going to talk about today, which is negotiated rulemaking and what we are seeing regarding negotiated rulemaking. So just a refresher, the department will announce that it's going to hold public hearings on particular rules, and then the department solicits nominations and selects the negotiators, and then selects and notifies the non-federal negotiators, and goes through the negotiated rulemaking process. And so these are the ways in which the department can go through that process. It's important to understand, as we talk about the negotiated rulemaking process, once the process begins, or even you have, like, let's use the Title IX process, you have the draft regulations, then the notice and comment period occurs, and then the department goes through and looks at all of those comments. And we've seen a huge uptick in the number of institutions that are actually responding or commenting on proposed regulations. And I think that's really important and something that you should do if you have questions or concerns about one of these. And then the department will answer those, potentially update it all. It goes through OMB, it goes through the process to become finalized. And once it becomes final, has the force and effect of law. Dear colleague letters do not have the force and effect of law and can be withdrawn by other administrations. When you have a regulation, a new administration can only substitute that, like we're doing in Title IX, or Congress could withdraw it, I guess, is the other option. So that's really the process as we look at negotiated rulemaking. So let's look at the topics the department has decided to tackle in negotiating rulemaking. And Abby's going to do a little bit of a deep dive with our last 10 minutes, but standards for administrative capability, change in control and ownership, borrower defense to repayment has been a huge one that we've seen, gainful employment. All of these are kind of big, huge financial triggers that we're looking at, and specifically the Biden administration is really focused on Pell Grant eligibility, as well as we kind of look at all of these from a very high level. And now I will turn it over to Abby to look at it on a little bit closer level to see what we're really anticipating in this year, in 2023.
Thank you, Haley. So on the screen, this is the list of rules that we have the final rule for. So we have borrower defense, closed school discharge, interest capitalization, total and permanent disability discharges, false certification discharges, public student loan forgiveness, 9010, prison education programs, and change in ownership. So the department's been busy. Here we have the borrower to defense to repayment. So most of these rules that are on the screen right here are all going to be effective this July. Borrower defense to repayment is no different. It will be effective July 1, 2023. For those of you that are familiar with borrower defense, currently there are 3 standards for borrower defense claims, and the way you determine which standard applies is when the Title IV funds were dispersed to the student. So this new rule is going to make a single standard for borrower defense claims. It also adds a new definition of aggressive and deceptive recruitment. This is a new concept that was not previously in the borrower defense rules, and it'll be interesting to see how this plays out. It contains things like limits to how often and methods for contacting prospective students. I think in some cases there might even be like an enrollment and then signing the enrollment agreement delay, like you can't necessarily enroll the same day. But there's just several different things in there that are new. There's also a ban on pre-dispute arbitration and class action waivers. And it basically just says these institutions cannot require them to participate in class action law, or waive the ability to participate in class action lawsuits, or they can't compel them to go through an internal dispute resolution process before filing their complaint. Basically, the department wants to preserve students' day in court. So continuing on the borrower defense side of things, they have a standard for when a claim can be filed. So you have to have substantial misrepresentation, substantial omission of fact, breach of contract, aggressive and deceptive recruitment, or a federal or state judgment or department adverse action against the student that could give rise to a borrower defense claim. So Pell for incarcerated students. This is something that is somewhat new, although the ban for Pell dates back to 1994. So the department is trying to reintroduce Pell for incarcerated students, and we expect students to be eligible by next summer. But in order to be a PEP, a prison education program, it has to be provided by a nonprofit institution, and there are several other eligibility criteria. But they do have to apply to provide a PEP, prison education program. We saw that application, the tentative draft of that application came out last week. It will undergo a comment period, and we expect that final application to be ready probably late spring, maybe early summer, in anticipation of that July deadline. Changes in ownership. So these new rules have to do a lot with the nonprofit conversion, where a nonprofit entity is converting to, or a for-profit entity is converting to a nonprofit entity. So the department adjusted the definition of nonprofit institution to prevent improper financial benefits to a former owner or other affiliated colleges. This is a trend we've seen over the last probably 5 to 10 years, where the department is not relying on IRS tax status to designate whether or not you're a nonprofit institution. And so they're updating that definition to reflect that improper financial benefit to former owners. The new rules also tighten the change process for when a for-profit institution can convert to a nonprofit institution. And then it also makes it unlikely for those nonprofit conversions to be approved if there's a former debt owed to a former owner. This would be like seller financing, or if there was a revenue sharing agreement or other arrangement with former owners or employees. The other thing that we're seeing that kind of surprised me in this rule, they did say that you could have a lease agreement with a former owner as long as it was fair market value. Previously, the department had kind of gone both ways on that, but the key to this is just looking at the benefits to the prior owner. Some of the other final regulations include total and permanent disability discharges. This basically streamlines the process to ensure a similar discharge process across all the loan programs. They made adjustments to align this with other disability programs like under the VA. False certification. This is another type of loans. You can have your loans discharged if the institution falsely certified your Title IV application. Public student loan forgiveness. They added some definitions and modified and restructured definitions related to qualifying employer and full-time for the PSLF purpose. Closed school loan discharges, they expanded the qualifications when students could qualify. I think they took this from 3 years to 1 year. You had to wait 3 years after the school closed to automatically receive a discharge. I believe that's now 1 year. And then we already discussed the pre-dispute arbitration. The key to that is just allowing students their day in court. There's a couple rules coming up. I think most notably we have the gainful employment rules, and I think also very important are the financial responsibility standards. Both of these, and I think they sent the administrative capabilities and certification procedures. These are all actually pending with OMB currently, which means they're in the process of finalizing those final rules, which is actually a little bit ahead of schedule. We anticipated an effective date of July 1, 2024. And so we'll just keep an eye out for those final rules as they develop. These are the other rules that all of these are currently pending with OMB to be finalized, and so we expect to see these later this year. Okay, I will turn it back over to Haley.
All right, well, we have just a couple minutes. Well, we have like 2 to 3 minutes left. So I'll just kind of generally tell you what the questions, we have a ton of questions, Abby, which is good because people are really wondering. But I mean, the majority of the questions are on third-party servicers, or a lot of them that we've gotten, and as what qualifies and what doesn't. And so the first question we've gotten is like, what about clinicals? Like, what if you have a contract with a hospital, that you are sending clinicals and they're providing instruction and providing educational resources and instruction for the students? And the answer is, under the plain language, that potentially could qualify, and you might need to let the hospital know that they would be subject to this. And I think that's one of the areas that I think needs to be brought up to the department, because I'm not sure that was intended at all. And I don't think I think that will make it much more difficult to get clinical placements if that's required from hospitals that are unfamiliar with the Department of Education and already have their own slew of regulatory institutions that they are responsible to abide by. And so that would be my kind of guess. But then I've asked about information management systems. Yeah, I mean, that's what they're talking about, like these types of systems. So it's a lot of different things that are on your campus. We've gotten a ton of questions that have come in, just what about this one? And what about this one? And, again, this is not fully settled. And I think that's why we wanted to have this webinar today, was to make sure you're aware of it and thinking through all of these. But attend the listening session. Somebody asked, how do I attend? I think you can just sign up online, right? Or there's a link to it that you can click tomorrow, and there's one tomorrow, and there's one on the 9th as well. And so make sure that you're getting your voice heard in terms of how this could be burdensome. So I think that's important. Other questions that came in were just talking about, shockingly, no one had questions regarding Title IX. You all must be very well versed and over Title IX presentations. So sorry about that, or maybe I was just clear enough for you. And then there are some questions regarding this personal liability. Is this just owners? Is it just the administration? I think still the jury's out on some of this as well, in terms of, it's written more broadly than that. It doesn't say just owners. It doesn't say, it includes them, but it doesn't have that. And so, Abby, wouldn't you agree that there's still going to be some questions and answers we hope the department will give us when it comes to who could be personally liable? And my guess is the department is going to tell you when you sign your PPA who they want to be signing the PPA as well. Not only if it's, a sole member or some other structure, but if it's an individual that would be personally liable. Abby, you want to add anything on that?
No, I think you nailed it. I think it goes in line with the department's trend to try to get more entities to be held jointly and severally liable under the PPA. So we'll continue to monitor that, and we're doing a deep legislative history dive to investigate it even further.
And when we say we, let's be honest, Abby's doing it for us and she's excellent. We appreciate it. So, all right. Well, with that, if you did ask a question and we couldn't get to it, we certainly will try. We'll send you an email response. Feel free to contact either Abby or myself as well. But that ends our webinar for today. Thank you so much for joining us. We hope this information was helpful. As a reminder, if you please click the Legal Educators Hours, the CEU icon, to make sure you're registered. And I saw that people had been told they were registered even at the beginning of this, and that's fine. You'll still get credit for that. And you'll get a certificate of attendance tomorrow. You'll also get a recording of this. So if you think it would be helpful that other people on your campus see it, feel free to pass that along. And then if you could complete that short survey, we greatly appreciate it. We also understand you're very busy. So thank you for listening today. That concludes our webinar. We appreciate it.